First offender DUI school, 1 session of the victim impact panel, 50 hours of community service work. That Mr. Patterson would request permission to pay off at the statutory rate. I believe that is all. And there also, Your Honor, there were 2 citations. One was for open container 24 TR 4704, and then running a stop sign 24 TR 4703. We'd ask that those citations be merged and dismissed.
Okay.
There's also 24 TR 4705 on that.
4.
No numbers.
Okay.
Thank you.
Is that state's agreement?
Yes, Your Honor.
All right, Mr. Patterson, raise your right hand, sir. Do you swear or affirm your testimony will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. Tell me your name and date of birth.
Benjamin Charles Patterson, August 22nd, 1989.
Are you under the influence of any drugs, alcohol, or medication?
No, ma'am.
Do you understand that by entering this plea, you give up your right to a trial where the state would have to prove that you were guilty?
Yes, Your Honor.
And if for any reason you're in the country illegally, any plea could affect your immigration status to include deportation? Is that a yes?
Yes, ma'am, sorry.
Have you had enough time to speak with your attorney?
Yes.
And you're satisfied with his representation?
Yes, ma'am.
Sir, I will accept your plea of no contest to the amended charge of reckless driving as freely and voluntarily entered. I will adjudicate you guilty and place you on probation for 11 months and 29 days. During that time, you must pay a $500 fine, $393 in court cost, complete 1 session of the victim impact panel, and 50 hours community service. You can buy that out at statutory rate. Probation will talk to you about that. You also must complete DUI school, and you have to sign up for that in the first 30 days of probation to make sure you have time to do it, okay? If all that is done at the 6-month mark and there are no violations, your probation may convert to administrative. The court will merge and dismiss 24 TR 4703, 04, and 05 with this plea. The deputy is going to give you a QR code for probation, so you need to scan that and get up with them in the next 24 hours, okay?
Thank you.
No prints, right? Right.
Yep.
30.
Your Honor, and I'm also covering for Ricky Dyer, if I could cover his case real quick so I don't forget. It's Evan McNamara, 24 MM 4191. He's requesting a continuance to the February pretrial. My understanding is the state is going to be subpoenaing the alleged victim to the pretrial.
It's the 12th, right? February 12th?
And then Chris Garrett on behalf of Brandon Myers, 24 CT 1823. I filed a motion to compel and a motion to suppress the breath alcohol test. I know the state is seeking to figure out what is going on with the breath alcohol video. I requested in the motion to compel. So I guess at this time we'd ask for a continuance to pretrial, and we can go ahead and get that motion to suppress set for a hearing.
Okay, 212 for that one. Brandon Myers, I'm sorry.
Okay. Then Chris Garrett on behalf of Madison Nodhurft, 24 CT 1579. I filed a motion to compel in this case. It's my understanding that the videos I'm seeking have been destroyed by the sheriff's office because they had met retention. I'm going to research that. I anticipate having a motion filed very shortly, or trying to work something out with the state. We could have a continuance to the February pretrial.
They met retention? Is it not that old of a case? All right.
Yeah, I don't know.
All right, February 12th?
Jose Ortiz. Then Chris Garrett on behalf of Jimmy Fan, 24 MM 3451. This is going to be a EPA. If I may approach, Your Honor.
You may. Thanks, sir.
Chris Garrett on behalf of Norman Platero, 24 CT 2176. I filed a motion in limine to exclude his field sobriety exercise refusal. My understanding is the state is going to offer an amended charge of reckless driving. Is that correct?
Not at this time.
Not at this time. All right, Your Honor, we will get that set for a hearing. I do anticipate filing probably another motion I should have filed by the end of the week and set for the same hearing date.
212?
Then Chris Garrett on behalf of Stephen Rogers, 24 CT 1446. I filed a motion to compel in this case. However, speaking with the state this morning, I believe that we've resolved the video issue. We should have them very soon. At this time, we just asked for a continuance to pretrial. I don't anticipate needing the motion hearing.
Are you withdrawing that motion at this time?
We haven't quite received the videos yet.
Okay, I got
So-
you. 212?
Okay, thank you, Your Honor. And then Chris Garrett on behalf of Ricardo Vargas Duarte, 24 CT 1980. He is unfortunately still in ICE custody. I've been unable to reach him. He's probably looking at deportation if the felony isn't dismissed. We'd ask for a continuance to pretrial.
In that case, given everything, I'm just going to issue a capias. Hopefully we can get him back. If not,
Well, Your Honor, I don't know how that'll affect his immigration proceedings. Could we have one more?
that's what we said last time.
That's what we said last time? Okay. All right, come on. It's up to Your Honor.
Capias hold till first appearance.
And I believe that's all I have on the docket. If I may very briefly approach about a vet court client.
Yeah.
a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in...
Thank you, Your Honor. Have a good day.
Thank you, Mr. Browning. I'm sorry, Ms. Merrifield.
Morning, Your Honor. I only have one left on the docket. Brittany Merrifield on behalf of Madison Norton. It's 24 MM 4226. I have a diversion if I may approach.
You may. Pre-trial diversion, you said? DPA. Thank you. I love that color. Is that all?
I believe that's all I have this morning.
Thank you, ma'am. Mr. Browning.
Coy Bradford, Julian Puga. He's got 2 cases on the docket. Puga. And Judge, we've got this worked out, seen a control date to get a plea agreement filed.
212?
That'll work.
Is that on both cases?
Yes, ma'am.
All right, thank you.
That's all I have. Thanks, Judge.
Thank you. Mr. Madden. So happy to see all of you here today. Really appreciate you.
Your Honor, John Madden here on behalf of Javier Perez. This is 24 MM 3210. We had set it on today's date for a plea or continuance. I did talk to the state late yesterday and then again early this morning. We've received a new offer from them. I feel confident that offer is going to resolve this case.
Yes.
So if we could move this to the next, I guess not the very next court date, but the next cycle, so we could get.
212, okay?
Yes, ma'am. I believe that'd be fine. We
That's
should
my
be able to
next
get wrapped up
pretrial,
for then.
so.
That'd be perfect.
Okay, thank you.
Thank you very much, Judge.
Thank you. Mr. Durrell?
Morning, Your Honor. May it please the court, Dustin Durrell. Your Honor, my client today is Mr. Gino Mitchell. This was just set with subpoenas to ensure we could have contact with the victim. It's my understanding the state has made contact.
Okay.
They provided an amended offer. I've talked to my client about it. He's asked for some time to speak with his family. If we could have one final continuance, I expect this will resolve you with a plea or trial next cycle.
212.
Thank you, Your Honor. I believe that's all I have.
Oh, okay, thank you.
Thank you.
Mr. Rayer? Morning.
For the record, David Rare for Mr. John Schock. We're set today without subpoenas for status. I provided some materials to the state, and I'll be following up with them about a couple of potential resolution options if we can set it for 212. I'm hoping to try to get it resolved that month.
All that discovery's been done, though, or documents or whatever? Yep. Okay, 212?
And that's all I have, Judge. Thank you.
Thank you. Thank you, Mr. Schock.
Thank you.
Mr. Catalani? Are you ready, or you need a minute?
Your Honor, if I can have a few minutes.
Sure. Mr. Maddox?
Yes, Your Honor. All right, 3 on the docket this morning. First, I'd like to call Mr. Mendoza Rivera, 24 MM 3813.
Buenos dias, señor. Buenos dias.
Your Honor, I believe the state may have an announcement in this case.
Yes, Your Honor. The victim and his father, who's a witness, complied with their subpoena to be here today. I did speak with them. they wish for these charges to be dropped, the state is going to enter a dismissal in this case.
All right. Sir, your case has now been dismissed. You're free to go.
That is all I have, Your Honor.
Thank you, ma'am.
Your Honor, next up I have Ms. Mary Martinez. She's present, 23 CT 1776. Martinez? Your Honor, I'm just going to pull out my phone. I have the state's offer on my phone here.
Okay.
Your Honor, Ms. Martinez is going to accept the state's amended offer to a reckless driving. It'll be with the following terms, Your Honor. It'll be an adjudication of guilt, 11 months, 29 days probation, $100 fine, 50 hours community service work, DUI school, the victim impact panel, and the cost of defense. The probation can convert to administrative probation after 6 months if all terms are complete and there are no violations. Your Honor, with respect to the DUI school, we would ask for 60 days to enroll in that. Ms. Martinez is currently seeking employment, just would like some time to save up the money and that sort of thing.
Gotcha. Is that the state's agreement?
Yes, it is the state's agreement.
Ms. Martinez, raise your right hand for me. Do you swear or affirm your testimony will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please tell me your name and date of birth.
Mary Martinez, 7/18/79.
Are you under the influence of any drugs, alcohol, or medication?
I do take meds.
Okay. Is it affecting your ability to appreciate and understand what's happening today?
No.
Okay. Do you understand that by entering this plea, you give up your right to a trial where the state would have to prove that you were guilty?
No.
You don't understand that?
I do understand.
Okay.
Yes, sorry.
That's okay. And if for any reason you're in the country illegally, any plea could affect your immigration status to include deportation, if that applies.
No, it does not.
Okay. But you understand that if it did, that would be a thing?
Yes.
Okay. Have you had enough time to speak with your attorney?
Yes.
Are you satisfied with his representation?
Yes.
Ma'am, I will accept your plea to the amended charge of reckless driving as freely and voluntarily entered. I will adjudicate you guilty and place you on probation for 11 months and 29 days. During that time, you must pay a $100 fine, a $100 cost of defense, and court costs in the amount of $363.
It's $368 since there's a $100 fine, I believe, Your Honor. If I forgot to announce the court costs, I apologize.
That's all right. $373.
Okay.
You must complete one session of the victim impact panel and DUI school. You have to sign up for that in the first 60 days of probation, just to make sure you have time to get it done, okay? If all those things are done at the 6-month mark and there have been no violations, your probation may convert to administrative probation, okay? The deputy's going to give you a QR code for probation. Make sure you scan that so you can get started and linked up with them within the next 24 hours.
Yeah, do you have stuff up? Okay, perfect. All right, thank you, Your Honor.
Thank you.
Your Honor, next up I have Mr. Hal Nguyen, 24 CT 2032. I don't believe he's here, unfortunately. Mr. Hal Nguyen. Yeah, I have no information at this time, Your Honor.
Okay, I will issue a capias and it will be hold till first appearance.
Thank you, Your Honor. That's all I have, I believe.
Thank you. Mr. David.
Yes, Your Honor. I have Mr. Eric Silvas, who's an inmate.
Anybody out of custody?
No, Your Honor.
Okay.
Good morning, Your Honor. This is Mr. Eric Silvas here on 24 MM 4116, 4115, and 3758. Your Honor, Mr. Silvas and the state have come to a resolution as to a global resolution as to cases 24 MM 4116 and 24 MM 3758.
Okay.
But not 24 MM 4115. So this plea will not include that charge, Your Honor.
Okay. Do I need to continue that?
Your Honor, we would just ask for that to be set at your next pretrial date with subpoenas.
Okay, so 4115 will go to February 26th with subpoenas.
Thank you, Your Honor.
3758. Mm-hmm. Right.
Yes, Your Honor. And as to 24 MM 3758 and 4116, the deal from the state, if I'm not mistaken, was 180 days in Okaloosa County Jail with credit for all time served, and adjudication of guilt, court costs, $100 cost of defense, and all remaining requirements of probation would be sent to collections.
I'm just making my notes. So.
Of course, Your Honor. He would also have to be assessed a $50 VOP fee and $50 cost of prosecution. And that's to revoke and terminate his probation, Your Honor.
The court costs on the new charge, are they $270?
Let me double check.
Yeah, that's what I was wondering.
Yeah, I'm not sure either, Your Honor.
Okay, now, Mr. Silvas, you were here earlier in the week and you wanted to just double check with your felony attorney. Did you get a chance to?
I never did. He the one that took care of.
And you feel good about it?
Huh?
You ready to go this time?
As long as it doesn't involve the, what are we doing here?
Mr. Silvas did not want to plead to the battery, Your Honor, which was,
Oh, that was the one that was the issue?
yes, Your Honor,
Okay.
which is why we set that for pretrial.
Well, we continued it so you guys would have more time to talk, so I just want to make sure he felt more comfortable today.
Your Honor, we don't need more time to talk. We're happy to just get the next pretrial date.
I understand, but I need him to tell me.
What's that? What do I need?
All right, let's go through the
As long
call.
as we can set, yeah, okay.
Do you swear or affirm your testimony will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, put your hand down, tell me your name and date of birth.
Eric Silvas, 33082.
Are you under the influence of any drugs, alcohol, or medication?
No, ma'am.
Your attorney has indicated that you wish to enter an admission to your violation of probation charge,
Yes.
right? And then a plea in the charge of trespassing and intimidating an officer.
What's the plea?
You would be adjudicated guilty on each case and sentenced to 180 days in the county jail with credit for time served. It would run concurrent.
Okay.
Is that what you want to do?
I guess that's what I want to do. I would have took it to trial, but
All right, hold on. Okay, so that's what you want to do?
yeah, let's get it
Okay.
on.
Do you understand that by entering this admission and this plea, you give up your right to a trial where the state would have to prove that you are guilty?
Yeah.
And if for any reason you are in the country illegally, any plea could affect your immigration status to include deportation, if that applies.
No, that don't apply, but yes.
Okay. I will accept your admission as freely and voluntarily entered in the VOP, and I will accept your plea in the new case as freely and voluntarily entered. In each case, I will adjudicate you guilty and sentence you to 180 days in the county jail with credit for time served to run concurrently. In the violation of probation, I will revoke and term your probation, waiving non-monetary requirements and sending monetary requirements to collections. You will be assessed a $50 violation of probation fee, $50 cost of prosecution, and $50 cost of defense, and I'll go ahead and send that to collections as well. In the new charge, there is a $100 cost of defense, $270 in court cost. I'll go ahead and forward those to collections, and then when you get out, you can get everything paid. Okay?
We're not on, you're not on. No, dead.
All right, thank you, Your Honor.
Thank you. No, the one battery is continued to 226 with speakers. Mr. Catalani?
Thank you, Your Honor. Your Honor, the first case that I have that I would like to address is Mr. Dakota Watson. He's right here present. Mr. Watson, case number 24MM2750.
Okay,
Your Honor, that's going to be a plea as charged,
okay.
with the understanding he would be adjudicated guilty. I believe is it either 6 months of probation or 1129 probation? 1129 probation, Your Honor. Fine of a $500 fine, $490 in court costs, 50 hours of community service work, which we're asking the court if he could be allowed to pay it off at the statutory rate. And, Your Honor, there's also a vehicle impound, but he doesn't have a boat and he doesn't have anything else. We're asking that the court waive that, and that's it.
That's it?
We don't have any more.
Okay.
That's the plea.
So the vehicle or vessel impound is not something I can waive. If you don't have a boat, they'll impound your car. which they put a boot on it and stays in your driveway, so they don't like put it in a lot or anything. But if he doesn't have a vessel, they'll do it with the car.
Yes, Your Honor, is that okay?
Yeah, for how long would that be?
10 days.
Yep. Okay, that's state's agreement.
Yes, Your Honor.
Raise your right hand for me, sir. Do you swear or affirm your testimony will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down, tell me your name and date of birth.
Dakota Watson, September 21st, 1998.
Are you under the influence of any drugs, alcohol, or medication?
No, ma'am.
Do you understand that by entering this plea, you give up your right to a trial where the state would have to prove that you were guilty?
Yes, ma'am.
And if for any reason you're in the country illegally, any plea could affect your immigration status to include deportation. Have you had enough time to speak with your attorney?
I have.
And you're satisfied with his representation?
Yes, ma'am.
Mr. Watson, I will accept your plea as freely and voluntarily entered. I will adjudicate you guilty and place you on probation for 11 months and 29 days. During that time, you must pay a $500 fine, $490 in court costs, complete 50 hours of community service, though you may buy those out at the statutory rate. Probation will talk to you about that. And your vehicle or vessel will be impounded for 10 days. Okay? Deputy will take your prints, and then he'll give you a QR code for probation, so you can scan that to get started. Thank you.
Your Honor, I'm sorry, does the court have an objection to early termination of probation, since he doesn't have that much to do?
If everything is done and completed at 6 months, I'll consider early termination. Thank you.
Thank you.
Thank you. Thank you, Your Honor. One other case that I have, Your Honor, is Mr. Adrian Omar Miller. There's 2 case numbers, Your Honor, in the citation, 24 CT 2633, which is a no valid DL, and 24 CT 823, which is a recall on a deferred prosecution agreement. May I approach?
Hmm? Oh. PIA is kind of a new term to me. Y'all are throwing me off with that one. Okay, so 24 CT 2633 and 823. And we're merging dismissing a TR?
Yes, Your Honor.
Okay, that looks good.
Your Honor, that's all I have. Thank you very much.
Your Honor, I just want to make sure on there, it says that it was the state's intention not to take any action on the failure to appear.
It does.
Okay.
All right.
Thank you, Your Honor.
Thank you. Mr. Shelby. Yeah.
How you doing, Donna?
I'm good. How are you?
Good.
So, all right, I'm gonna come back to, can you get Mr. Catalinic for me? Randy, come back. All right, what's going on? Did you get signed up?
Yeah, I did my probation and everything. I just doing reevaluation. And I went the 27th, and they rescheduled it for 5th of next month.
Of course they did. They knew you had a court date. They're messing with us, Mr. Shelby.
Yes, ma'am.
All right, well, let's try again February. I know you're trying, okay?
Yes,
I know
ma'am.
you are. So don't worry about that. I'm gonna see you back February 12th. Wait, when is it, the 5th, you said?
Yes, ma'am.
All right,
5th.
February 12th at 9 o'clock, and hopefully we'll get it taken care of by then.
Yes, ma'am. Thank you so much.
Mr. Catalinic, the clerk, the case, okay, I didn't see that part. The disposition you wrote in this only addresses 24 CT 2683.
Your Honor, should be addressing both of them. I know on the first page we didn't have that addressed, but the case number should be there. That's
So if the attorneys can approach, I think, come on, I think what may have happened is when you wrote this case number, you combined the two.
Shingles and metal, re-roof, repairs,
So can you just
and leak
fix that and make sure to,
For
so it's
all of your
concurrent
roofing
sentences
needs,
on each case?
Call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Yes, Your Honor. That was one, I think that just got confusion, my going up to Crestview. So I think Jill had submitted it from up there, but I will track down, but there is a written plea agreement that's signed by both parties on this case, Your Honor.
So I'll continue it to 2/12 for you guys to find that and get it to me.
Thank you, Your Honor.
It's lost in the void.
Don't leave yet, Randy. I want to make sure we're all good with this plea agreement.
Yeah, it's almost there.
So this should be 3-3, not 8-3. Do you agree with that, Mr. Kalanick? We can bring Mr. Arce if you'd like.
Yes,
Okay. Morning, Mr. Arce.
Morning, ma'am.
You want to take a minute to get set up with all your papers?
That should be fine.
Okay, give me just a second. Oh, come on, Angela. Okay. Mr. Arce, if you would please raise your right hand. Do you swear or affirm your testimony will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, Mr. Arce, we're back today for the court to rule on your motion to vacate the void order from Judge Schlechter. You have the opportunity to be represented by the public defender if you so wish. We have them on standby. Do you continue to choose to represent yourself?
Yes, I do.
You understand I could give you an attorney if you want one, and if at any point you change your mind on that, I'm happy to address the situation.
Yes, ma'am.
Okay. In choosing to represent yourself, I need to ask some of the questions we've gone through every time. How far did you go in school?
Bachelor's degree.
Do you suffer from any mental health issues?
PTSD.
Are you receiving medication for that?
Yes.
Is it affecting your ability to appreciate and understand what is happening in the courtroom?
No.
Okay. I know you have experience in court previously having worked in law enforcement, correct?
Correct.
And you have filed a great number of motions, and we've had hearings, and you're comfortable representing yourself in court?
Yes.
Okay. Has anything changed since our last hearing with regard to that issue?
No, we still have actually, yes. There's one more, deposit of motion that I placed on
I'm
the
sorry,
docket.
specifically with your desire to represent yourself?
Oh. No.
Okay. The court does find that Mr. Arce is competent to represent himself in this situation. Let's first address the motion to vacate the void, and then we'll get to any additional motions. Also, the first DCA still has not ruled on your appeal, so my jurisdiction is limited to the bond issue. I read Rescindes versus Bradshaw, 935 Southern 2nd 19, and Dominguez versus Cloutier, 377 Southern 3rd, cases provided by Mr. Arce at our last hearing. In Bradshaw, the setting of no bond occurred at first appearance. And in Dominguez, the issue also regarded a high bond that the defendant could not meet. These cases are distinguishable, Mr. Arce, because in your case, a bond was set, but then revoked by Judge Schlechter, which is a completely separate issue from the initial setting of a bond. So respectfully, sir, the motion to vacate is denied. You said you filed an additional motion for me?
Yes.
Is it about bond?
Is it a what now?
Is it about a bond issue?
It's not about a bond issue, but I'd like to make a motion for a bond issue.
Okay, let's do one thing at a time. What case did you file it in? Because I'm not.
On October 2nd, the court gave an order to keep the DCF records under seal and stated that they were not necessary to the resolution. Besides that, for all the other discovery, we've given discovery throughout this entire process, and we're up to the fourth amended discovery at this point, Your Honor. So we've been maintaining discovery throughout.
Okay.
Well, I'd like to object to that. Yes, discovery was made, and then that particular date, discovery was brought forward, except for it was limited. Now, instead of giving, every instance of the discovery that I requested, they only gave me one instance of the discovery that was completely redacted. And the state conducted ex parte communication with the Judge Schlechter at that point to have it, continue to have it redacted under the guise of, HIPAA.
I'm sorry, when you say it, are we speaking about the medical records?
Yeah, well, not exactly the medical records, it's testing.
Oh, drug testing?
Drug testing.
Okay, thank you.
It has nothing to do with HIPAA whatsoever. But that's what they were trying to, the state was trying to withhold that discovery based off of HIPAA, claiming that HIPAA prevents the DCF from allowing that information to come forward. However, there wasn't. There's actual case law showing the opposite. I'm sorry.
It's okay.
Now, for the case law that they presented was only was for, if I remember correctly, it was after our parents lost their rights to the children. So they weren't allowed to see the medical records of their children after the fact, after they lost parental rights to their children.
Sure.
All right, so that was the case that was presented. But in that same category of cases that they looked up, they jumped over another case that was almost identical, but it was CF. Basically, it was the parent that did not lose his parental rights that was able to see the medical records. But regardless of the cases that they presented or what cases were available, HIPAA does not preclude drug testing, and especially it's not a means for a defendant or a person to evade criminal prosecution. So HIPAA is not an issue, and again, what the state has already, brought forward, they only brought one instance of the drug urinalysis. There was multiple instances where the alleged victim was drug tested, and it was the exact same. It was the very next day that I brought it forward and had DCF drug tester. And I know it happened because I discussed it with DCF and Families First, and I've been asking for it ever since. I think the first instance I've asked for it was on the 28th of July 2023, and I've been asking for it ever since. I know it's there. I know it's. But what the first instance, not the first instance, but when I finally took over the case from Mr. Hall, I immediately asked for the discovery, and I asked for the specific drug testing.
Are you looking for a specific date or Ms. Arcee's drug testing for her whole life? Or?
No. I was looking for just a specific date. In fact, it's just to make it easy. I framed in 1 month. Now, July 27th,
July of 23, is that what you're looking?
2023 to August 2023. All right, so that specific bracket of dates. Because on the July 28th is when her initial testing was done, but the state only provided August 4th, which is the very next Friday. At that point, the drugs in her system had time to metabolize. So I don't know how much of the drugs were in her system at that point, because it was heavily redacted. And Schlechter pulled a Schlechter and took the information outside the court and did an in-camera review, supposedly. But there was other ex parte communication, like I said, between the state attorney at that point, state attorney at that point, with Judge Schlechter. Apparently, there was some additional information on one of the documents that he's seen and then sealed, pertaining to the information that was on the drug testing results page. So there was 3 documents that was given to him.
Okay.
But none of them were the documents that I requested, that I have requested for this entire year and a half now. And there's no way I would be able to prepare for any trial without those documents, because they are exculpatory evidence. Without them, it doesn't explain exactly what I was doing, what I was attempting to do.
Okay. Is that all?
For that,
We're speaking about the drug testing records.
the drug testing records,
Okay.
yes. There is drug testing records from the 28th. That is the first day that she was drug tested.
Okay, so you do, not that you have them, but those have been made available to the court for review.
No.
You're saying no?
No.
Only August 4th?
Only the August 4th was made available for the court. And the state attorney just kind of, well, this is all I'm providing you.
Okay. Let me address the state. Everything that Mr. Arce said, is there anything new from what Judge Schlechter heard in October?
No, Your Honor.
Okay. The law of the case is what it is, and I'm going to get to explaining that in just a minute, but I would like to know, did the state seek drug testing specifically from July 28th?
Yes, Your Honor.
Was any available?
No, Your Honor.
Okay, thank you. Maybe see.
Thank you.
Mr. Arce, DCF, I don't know anything about the case you're telling me about, but I can tell you that civil burdens and relevance regarding drug testing is very different in criminal cases. Evidence of drug use can, not always, but can be relevant to explain a witness's ability to recall what happened that day, right? It is not relevant necessarily to explain why someone else did something. Does that make sense?
I understand what you're saying.
And what you just said is we need those records to help us understand why you did what you did.
Mm-hmm.
The drug records from August 4th, which according to what I'm looking at occurred after this event, wouldn't be relevant one way or another because they can't illustrate what Ms. Arce was experiencing 6 days prior when this event allegedly happened. See what I'm saying?
I understand. Okay.
Does that make sense?
Well,
Like if something happened on Monday, whatever I did on Friday wouldn't be able to tell me how I saw things on Monday.
well, the thing is that I was escorting her out of our house
On
because
July 28th.
on July 27th.
Well, but I'm saying anything that may have happened August 4th wouldn't matter.
No, August 4th, absolutely not. It wouldn't matter. I'm not really worried about that information so much as that
You're worried about the 27th.
I'm worried about the 28th, all right? I know drug testing was done on the 28th, all right? The reason that it is relevant is because I escorted her out of the house because
Be careful, you don't want to talk about the facts of your case, but I'm never going to let you not say what you want, but I just want to make sure you're advised that anything you say can be used against you, so.
Yeah, absolutely. As a law enforcement officer, I understood that she was under the influence of an unknown substance. So I escorted her using a police escort, which is a completely normal, everyday, non-invasive maneuver to bring somebody from one location to another location safely. All right? And in the process of that, she lost her mind. Once we got to the front door, she smacked my face, knocking glasses off my face. All right? I knew she was under the influence of drugs, and that's the reason why I keep asking for these testing results. That's the reason why I requested them in the first place.
Well, I understand, but
And
the
so-
argument is that they don't exist.
Oh, they do exist.
How do you know that? Because the state is telling me that they do not.
Because I talked to the DCF person that would actually drug test, and they're the ones that suggested that I have her Marchman acted.
Who? You say the
I'm
DCF
talking, oh, I'm
person,
sorry,
but you have a
DCF, it's Mrs. Sherry Dunsford, and it was Family First Network, I got her name somewhere. They both had an interview with me, along with, I don't know, a court-appointed psychologist over the phone. And they all conferred that she did, or they didn't specifically say that she was under the influence. What they said is, have I heard of the Marchman Act?
Right.
All right?
And if that was your concern, you could apply for it?
Yes.
I'm guessing. Okay. But you're telling me today that Sherry Dunsford with Families First told you that Miss R.C. was drug tested on the date of this incident, which, according to this police report, was July 28th, 2023?
Yes.
Okay. And the state, you're telling me that that is incorrect?
Yes, I apologize.
Okay. Have you talked to Sherry Dunsford?
I personally have not, but Ms. Gaynor talked with everyone over at DCF.
Which was the prosecutor before you?
Yes, Ms. Gaynor was in charge of the case at the time that this hearing was taking place.
Okay. So when a trial court rules on a motion such as this, and there is an order from October where Judge Schlechter reviewed the documents, found they were not relevant, and excluded them, that is the law of the case. What both of you are telling me is that what Judge Schlechter reviewed would have been testing from August 4th, correct?
Correct.
Also correct?
Correct, Your Honor.
Mr. R.C.'s motion to compel specifically addresses testing that he alleges occurred July 28th. Correct, Mr. R.C.?
That is correct.
Do you understand?
Yes, Your Honor.
I believe in order to come to a resolution on this, we should probably hear from Sherry Dunsford or a representative of Families First to testify, because while I appreciate both of your arguments, it's all hearsay coming from you guys, right? To tell me if that test exists or not. Now, Mr. R.C., if it does exist, I would also review it in camera. That is absolutely the court proceeding. Drug testing falls under the medical records, for purposes of the law. So I know you're not a Judge Schlechter fan, but I do believe his procedure in doing it that way was correct. It would not be ex parte. It would just be the court reviewing in camera. So if those records exist, I just want to put you on notice that I would follow the same procedure.
That's perfectly fine.
Okay.
That's perfectly fine. I have no issue with that. I just had issue with the state only bringing in the one testing result.
I gotcha. Well, and there's some conflicting argument about what DCF and/or Families First is going to tell me about whether or not that test exists. So I think we need to put them under oath, and I have to go with whatever their testimony is.
I don't believe Ms. Gaynor actually disputed the fact that there was other testing results. She just wanted that testing result redacted, and that's all that she gave me.
I gotcha. Well, what we have all agreed that what's important is the day of the incident, and that is July 28th. So that is what we're going to talk about at that hearing.
Yeah.
Okay? So let's set that for a hearing, shall we? Mr. Arce, even though you have issues on appeal, do you agree that the court does have jurisdiction to hear this motion?
Absolutely.
Okay. I don't even know what today is. Can y'all help me out?
29th.
Thank you. Thank you very much. January 29th. Let's look at, my next judge trial is February 24th at 9. To the state, can you, Sherry Dunsford, correct?
Sherry Dunsford.
Can you subpoena her?
Yes, Your Honor.
And we are going to hear testimony specifically limited to if drug testing was conducted on Mrs. Arce February 28th.
February 28th between.
July 28th, 2023.
Yeah, between that date and August 4th. I'm just saying, you don't want to just limit it to that one specific day. I don't know if it was done, I don't know if additional testing was done Monday or additional testing was done Tuesday.
Yeah, but you just told me you knew it was
I
on that
knew,
day,
I knew it was Friday,
which is the 28th.
which is the 28th. I definitely know about that one, but I don't know if additional testing was done the next Monday. There might be more than just the one.
Right, but remember we talked earlier about what's relevant is it's.
Right.
So what, any drug testing after that would not be relevant?
It depends on how long it takes to metabolize.
Well, if she used it on Friday, then it's going to be live on Friday. You have to agree with that, right?
Yes, I do.
Okay. All right, so let's talk about the 28th, and we'll see how the testimony goes. You know, maybe she'll say we couldn't get to it that day, so we had to do it the next morning, and then I would be happy to consider that as
Yeah,
well.
so, well, she rushed out after she found out.
She, Miss Arce?
No. Ms. Dunford, she rushed out of my interview with her so that she can get the testing conducted.
All right, well, we'll see how the testimony goes. So February 24th at 9 o'clock, I'm going to motion to compel hearing regarding drug testing 7/28/23 or soon thereafter. How about that? You agree with that language?
That's perfectly fine.
Okay. I didn't see any other motions, right?
Not
Written,
written.
okay?
I just want to verbally motion for a bond hearing.
I know, Mr. Arce, we're not going to do that. I really appreciate your tenacity in continuing to do that, but at this point, we're kind of spinning our wheels on that. I'm trying to progress your case forward. Myself, other judges have all ruled that this is the proper thing, so I'm not going to entertain another bond hearing at this time. I ruled on one just a few minutes ago, okay?
Yes.
Thank you. The state was going to reach out to the victim in this case. Mr. Arce is not inclined to take any offers, but if one existed, because we've gone on for so long, I wanted it to be on the record for preservation. So did you have a chance to reach out to the victim?
Yes, Your Honor.
And what, if any, offer exists at this time?
The offer from the state at this time is we would be willing to dismiss 23 MM 3810, that's the domestic battery charge, for a plea to 23 MM 4253, which would be adjusted to be 2 violations of injunction, and those would be each a withhold, 11 months, 29 days probation, $270 in court cost, batter's intervention program, no contact with the victim, and abide by the injunction, and the 1129 would be consecutive to allow for completion of the batter's intervention program.
Okay. So there's 2 counts.
There's 2 counts.
Consecutive on each count.
Yes, Your Honor.
I got you. And once Mr. Arce successfully completed, okay, I understand. It's 270 on a violation of injunction?
Yes, Your Honor.
Okay, I just want to make sure. Okay, so now you have that information, Mr. Arcee. Do you have any questions about the state's offer?
So when the violation, or excuse me, when the injunction is, oh, no, I don't have a problem with that.
Okay. Well, something to think about.
Yes.
As we talked about earlier, I do not have jurisdiction to accept a plea right now because things are pending at the first DCA. When that's done, if you have decided you wish to do that, I would consider it, or if things are withdrawn at the first DCA, whatever happens. But it's very important to me that you're informed and have all the information, so that's why I asked for that to happen. Okay?
All right.
All right, so, Mr. Arcee, I will see you back on February 24th at 9 a.m., and we will hear from Ms. Sherry Dunsford. All right. Anything else before the court at this time? Nope. All right, thank you all so much.
Thank you, Judge.
Your Honor.